Hey everyone, I'm Matt Dolan with Dolan Divorce Lawyers in Connecticut, and today what I'm going to talk about is how pets are dealt with in a divorce. Unfortunately, pets are treated by the court as just personal property. I have a dog myself, Ziggy, and I certainly don't consider him just personal property, but in the eyes of the court, that's how pets are considered. So when the court's figuring out who should retain a pet, it's not like a custody case where, with children, the court is usually considering what is in the best interest of the children. And, there's a whole number of factors they have to consider in determining what is in the best interest of the children with regard to what the custody schedule should be. Unfortunately, the courts do not have that same obligation to consider what is in the best interest of the pet, and they really just have broad discretion to kind of do whatever they want with regard to allocating which party should receive the pet or whether both parties should receive some ownership of the pet. Now, with that said, while they don't have the obligation to consider what is in the best interest of the pet, at the same time, judges are human beings, and they're usually going to kind of want to do what they think is best for the pet, or at least what's best for the family in determining who should, retain ownership of a dog, for example. So they can either award that, one of the parties retain the animal and all the expenses associated with the animal, but they can also be creative in saying that, maybe both parties have some sort of joint arrangement of visitation with the animal, split time with the animal. But that obviously also comes with the added complication of splitting expenses associated with the pet. And that can be complicated. And in that, if there's a $3,000 surgery, then one party thinks it's worth it, but the other party says, oh, it's just continuing the misery of our dog if we have that surgery. So it can be complicated if there's some joint ownership situation associated with the pet. So oftentimes a court will just award one party to have a pet, but that's not to say that you can't be creative in crafting some sort of settlement agreement that says that, there's going to be some shared arrangement with the pet, and, that any mutually agreed upon medical expenses are to be divided equally, by the parties. And if, maybe if one party feels that the surgery is necessary and the other doesn't, if one person's willing to pay for it, maybe they pay for it, and they're 100% responsible. They have the option to pay 100% if they feel that the surgery should happen. So it can be kind of sticky and complicated if there is a joint ownership situation, but you can be creative in tailoring something with your ex-spouse as far as sharing a pet. Now, again, judges are humans. So if you are arguing for why you should get a pet and why you should keep a pet in a divorce, you're going to want to cite things such as, who is responsible for purchasing the pet. Maybe one of you owned the pet prior to the marriage, and that will strengthen your argument for why you should keep it. Or maybe, you're the one who always is responsible for walking the dog and feeding him or her, and really is the primary caretaker for the animal, and that taking him or her to vet appointments, things like that. So those are the arguments you're going to want to make if you are unable to reach an agreement with your spouse as far as why you should retain ownership of your animal. Because again, judges are humans, and they're usually have common sense, and they're going to want to give your animal to the person who is a better caretaker for that animal. So those are the basics of how a pet, how custody of a pet is determined in a divorce. If you have any other questions, as usual, feel free to contact our office.